All right. Thank you, everybody. Welcome back. Hope you have your coffee because we're going to get running again here. Our next session is the first of our two Back to Basics sessions. So we hope this is very practical. We're going to cover a lot of ground really quickly, but we hope this is very useful. So without further ado, I will turn this over to our panel moderator, Jack Sullivan. Jack, take it away.
Thank you, Ryan. Good morning, everyone. Thank you for joining us here in person and through the magic of the internet. It's very great to see so many people who have been able to make it as we start to kind of get back to normal post-pandemic. And that actually is sort of one of the themes that we have here in our session is as employment law practitioners and human resources professionals are sort of getting back to what this new normal is post-pandemic, it's a good time to revisit a lot of the basics and go back over some of the more complicated issues that we have to face. And so today we're focusing a lot of our time on reasonable accommodations in addition to other issues. Before we get going though, I'd like to just have my colleagues introduce themselves. I'll start. I'm Jack Sullivan. I am a partner here in the Minneapolis office. And it's, as I said, great to see everyone here and to be with you today. And I'll pass it over to Drew and have folks just introduce themselves on the way back over from my left to my right.
Good morning, everyone. My name is Drew James. I'm an associate on Dorsey's labor and employment team here in Minneapolis.
We're just like way out of order of the list in our title slide. My name's Trevor Brown. I'm a partner in the labor and employment group, also here in Minneapolis.
Hi, everyone. Nice to see so many in-person faces. I'm Anabel Cassady. I'm an associate here in Minneapolis.
So in our session, we're going to begin with just a kind of a table setting about where the world is and where we all are with regards to the pandemic and returning to in-person work. And then we will focus on vaccines, accommodations, both as it relates to accommodations from pandemic-related requirements, and then also just accommodations in general. I think one of the areas that we see there being a lot of discussion for employers going forward is what do you do when you have people who are requesting a work from home accommodation for some reason that has nothing to do with the pandemic. So in the past, it's been a typical response that working from home is not is either overly burdensome, is not a reasonable accommodation, but the whole world has seen different in the last 2 years about how work from home can work. And so we're going to be discussing some of those issues. And then finally, one of the issues that will be in something that we're dealing with going forward is dealing with and protecting trade secrets, confidential information when we have a workforce that is not in person all of the time, as might have been the case prior to the pandemic. So just a quick, reminder about sort of where everything is with the pandemic. We are nearing 100 million confirmed cases of COVID-19 in the United States, and we have exceeded 1 million deaths. Nearly 80% of the population has received at least one vaccine dose. About 2/3 are considered fully vaccinated with regard to the initial series, but less than half have gone through the recommendation of having at least one booster. So that's sort of the backdrop of sort of what we are seeing in terms of our workforces, who's vaccinated, who's not, where people stand. You may know that within the last week or so, the CDC has changed its guidance for what it recommends of people after there's been an exposure. So there is no longer a requirement for a quarantine on exposure. Instead, the requirement is that if you are exposed, you wear a high quality mask, you get tested on the 6th day after your exposure, and then continue sort of these reasonable precautions, which do not include quarantine, through the remainder of the 10th day after your test. How this bears on what we're talking about today is obviously, I think, we've all been dealing with people who have tested positive or have been exposed, I should say, and therefore that's a reason that they're not able to come to work because they're following the quarantine. This is now the guidance from the CDC, is that if someone has been exposed, then they are largely able to go about their life wearing a high quality mask, remaining distant from people, but not quarantining from home. That 6-day test, if that is positive, then there is the requirement for someone to isolate immediately. And I want to walk through all this in this way, just because I know a lot of employers, and I've had a lot of clients who say, we follow the CDC guidelines, and that's their response to their workforce when an issue comes up. That's their response to anyone from the, I've had that happen with a labor board investigation and organizational petition of, what are your current policies? You say, well, we follow the CDC guidelines. This is what those are today. Upon a positive test, whether that is a test that someone does for their own diligence, or whether it's a day 6 test after a known exposure, then these are the isolation requirements that look familiar. So stay at home, isolate from others, wear a mask, continue that through day 10. And then at that point, depending on your symptoms, then the recommendations vary. So if at day 10, there are still symptoms that are moderate or severe, or a fever, then the person is asked to continue to isolate.
I think it's a surprise to no one that return to in-person work has been slow. We're seeing it here in our office. We're seeing it in the offices of a number of our clients. A number of employers, including those that were big proponents of in-person work, have revisited and softened their stance on coming back to work in person. This response comes in response to the continuing pandemic, what's known as the hot labor market, and then, of course, employees' preferences to both work with a flexible schedule and in a more flexible location. According to survey findings from the ADP Research Institute published earlier this year, I think in April, 2/3 of the respondents, so 64% about, said that they would consider looking for a new job if their employer wanted them back in the office full time. The resistance to returning to the office full time is even stronger among younger employees. About 71% of 18 to 24-year-olds said they would consider looking for another job if their company insisted that they return full time, compared to 61% of 35 to 44-year-olds and 56% of 45 to 54-year-olds. These survey results make clear that remote and hybrid work is strongly desired among the workforce of all ages, and that it's very likely here to stay.
We'll spend a few minutes talking about kind of the current lay of the land with regard to vaccine requirements. And for that, we'll turn it over to Drew.
So we'll start today with a little bit of expectation setting. And my hope is that the next 3 minutes of content, everyone in this room probably already knows. But a surprising number of people seem to think that because of some high publicity Supreme Court and federal court decisions, that vaccine mandates are now not allowed, or masking mandates are now not allowed. And we just wanted to be very clear that in many states, private employers can still implement vaccine requirements, and they can still implement masking requirements. And of course, the two federal decisions that I'm talking about are on January 13 of this year. The United States Supreme Court did stay enforcement of the OSHA ETS, which saved us about 3 panels worth of content for you all. That was basically a full-time job for us. And so on the one hand, that's a relief, but on the other hand, it created quite a bit of uncertainty and once again, returned some of that power back to private employers. But it was a very narrow decision on the grounds of when OSHA can use what's called an ETS, an emergency temporary standard, and it had nothing to do with what private employers can or cannot do in most states. And likewise, in April of this year, on April 18, there was a federal judge down in the Middle District of Florida who struck down the FAA's masking requirement. So now when we all go to the airport, if you don't want to wear a mask, you don't have to wear a mask. And whether that's a good or a bad thing, it has nothing to do with whether private employers can implement masking mandates. And so again, hopefully everyone in this room, everyone online, this is not news to any of you. But we just hear all too often at the proverbial cocktail party that this is a thing of the past, and it really is not. This is something that private employers are still doing, but it's also worth noting that if you're going to have masking rules and if you're going to have vaccine requirements, you have to account for accommodations, including medical and religious. The other thing that we're hearing perhaps far too often is this idea. So when the EEOC started issuing guidance in terms of COVID-19, it happened fast, it happened furious, and it got headlines virtually every time there was guidance. As the years have gone on, the headlines have disappeared, even though the EEOC has continued issuing guidance. And so I think it's important that everyone appreciate that the EEOC does continue to issue guidance, and it's important. And it's something that you need to stay on top of if you're trying to have your policies and practices be current. And so, for example, just last month in July of 2022, the EEOC updated some really important guidance. So we're not going to cover everything that they did today, but there are a couple that are worth knowing at this point in time. So, for example, as shown on the screen, if the requirement, if there is a job-related and business necessity requirement, an employer may administer a COVID-19 viral test as a mandatory screening measure, but that's very different than antibody testing. The EEOC has clarified that because the antibody test doesn't measure for a current infection, an employer does not have a business need to be able to impose an antibody test. Similarly, it is okay for employers to screen applicants, for example, before their first in-person interview for a role for symptoms of COVID-19. But if you're going to do that, you have to do that for all applicants or for all employees in the role. You can't be picking and choosing which have to be tested and which will not be tested. Similarly, it is okay to require employees to consult with a qualified medical professional before returning to work. If you know that they have tested positive for COVID-19, you can require that if there is a genuine need for that medical information. So for example, if you have an employee whose duties include a significant amount of physical exertion, they're lifting heavy weights, that type of thing, you might need to know whether or not they are able to do that. And so in that situation, you may be able to consult qualified medical care. And by the way, one more point before we move on to a couple more of these. Be really careful about taking unilateral action to try to protect people who you think may be susceptible or vulnerable to COVID-19 and its symptoms. That is something we see every once in a while where an employer says, well, we're just going to go out of our way to make sure that the elderly are protected or people who are pregnant are protected. And even though your heart may be in the right place, that is itself potentially discriminatory. And so you need to be really careful about the way in which you're implementing benefits. So another thing that the EEOC has talked about is that it is okay to require vaccination-related documentation, especially if you're implementing a vaccine requirement. You can ask your employees which of you are vaccinated, and you can even collect the vaccine cards. But a change under the EEOC guidance is that it is now considered a confidential medical record under the ADA. If we had talked 6 months ago, I would have said it's a best practice. It's now no longer a best practice. You have to do it. And so that means that those records can't be put in personnel files. They have to be stored separately, and they can only be shared with employees who need to know that information in order to perform their job duties. You can't just have a list posted next to the water cooler of everybody who is or is not vaccinated. And then another topic that has come up once in a while is the talk of incentives to obtain vaccines. And the EEOC has now made it explicit that there is a different requirement when the employer is actually administering the vaccine. If you're having someone come on site and administering the vaccine, then there is a coercion requirement. You cannot create any incentive that would be coercive where an employee thinks that they have to or should get the vaccine. But if you are doing it through a third party, and if you're creating, for example, a raffle or a monetary benefit, there is no limit to the amount of that incentive for the employee to go get the vaccine.
So Drew mentioned the job-related and consistent with business necessity standard for a COVID test policy or COVID test in going forward now that we're sort of out of the prior pandemic-related guidance. Job-related and consistent with business necessity, as you know, is not a new standard. It's the old standard. It's the standard that always applied to employers if they were going to be considering a medical examination or a medical inquiry of any employee. It's a requirement of the ADA, and it is, again, not a new standard. It's a place where an old standard is being brought to bear, but in the COVID context. And that's, I say all that because that's the focus of our next conversation is reasonable accommodations, and specifically working from home as a reasonable accommodation. And just for the backdrop of that, so employees are entitled to a reasonable accommodation to perform an essential function of their position when providing it is not an undue burden on the employer. They are not entitled to the reasonable accommodation that they want the most. They are not entitled to the reasonable accommodation that they asked for first. They are entitled to a reasonable accommodation. And so the law requires employers to engage in an interactive process with an employee who requests a reasonable accommodation or who provides information that indicates a reasonable accommodation is required. I really have always loved the phrase engage in an interactive process, because to me it is quite literally what a lawyer would say if they were defining have a conversation with someone, and so that's what I tell people is when someone asks for a reasonable accommodation, have a conversation, find out what they're asking for, find out what the issues might be, and then consider what they're saying as you go forward. So what we wanted to do was to talk about just generally, it had been the case, in the pre-pandemic world, where I've had clients who have asked, I've had a situation where an employee says they have PTSD and they would like to work from home as a reasonable accommodation. So what we want to spend a few minutes discussing is, has the assessment of that and the analysis of that changed, given that we've all seen the reality that working from home is a possibility for us all, because that's what we had been doing for a large stretch of the last 2 years. With that, I'll hand it over to my colleague, Anabel.
Thank you, Jack. So yeah, as Jack was mentioning, with a number of workplaces coming back to the office after 2+ years of being remote, the sentiment around telework, working remotely, has changed quite drastically. And while the law is still struggling to keep up with the change, you as employers are obviously having to navigate some considerable uncertainty in the interim. So of course, some positions have essential functions that clearly require the employee to come to work in person. But the uncertainty really lies in positions where an employee with a disability has been working from home for some time during the pandemic and has been adequately performing all duties without any performance concerns. In these cases, the question is, can the employer still take the position that an essential function of the job requires the employee with a disability to work in person? So according to new guidance from the EEOC, this is still essentially the same. If there is no disability-related limitation that requires teleworking, then the employer does not have to provide telework as an accommodation. Or if there is a disability-related limitation, but the employer can effectively address the need with another form of reasonable accommodation at the workplace, then the employer can choose that alternative to remote work. What's new here is that an employee's temporary telework experience during the pandemic may be relevant to considering a renewed request by the employee for an accommodation to continue working remotely. So in its guidance, the EEOC has opined that the temporary period of allowing the worker to telework may serve as quote unquote a trial period that demonstrates whether or not the worker can adequately perform all essential functions while working remotely, and that employers should quote unquote consider any new requests in light of this information. So in other words, the EEOC may use an employer's previous remote working arrangements during the pandemic as evidence that the employees should be permitted to continue working remotely, and in doing so they're able to accomplish the essential functions of their job. The EEOC's guidance does make clear, however, that the ADA does not require employers to eliminate an essential function as an accommodation for an individual with a disability. So for instance, if an employer allowed workers to telework because of COVID and temporarily excused an employee from performing one or more essential functions while working remotely, this does not mean that the employer permanently changed the job's essential functions or that remote work is always a feasible accommodation. In such a case, after the workplace reopens, the employer would not need to grant an accommodation request to continue working remotely if it would require continuing to excuse the performance of an essential function. So with that, Trevor, you want to discuss some recommendations and best practices for employers facing accommodation requests to work remotely?
Sure. And I think the point that I want to touch on is picking off when Ryan introduced our panel today of kind of back to basics. And I will actually start by telling you a very quick story about being on the phone with a client not too long ago. And the point of this is to make sure that you actually have an accommodation request. And so this particular client, I hopped on the phone, we're chatting, and even though I'm from Wisconsin, I consider myself very Minnesota nice, so I didn't interrupt the client. And about 15 minutes into the client running through, this employee really wants to work from home, and here's his position, and here's why we just don't think we could make it work, and et cetera, et cetera, et cetera. I asked, hold on, has the employee actually requested a religious accommodation or a medical accommodation, an accommodation for a disability, or are they just asking to work from home? Very good. It was an awkward silence, just like that. And the client is a very sophisticated client, had a like, oh yeah moment. The requirement that there actually be a disability for which the employee is requesting an accommodation, or a sincerely held religious belief for which the employee is requesting an accommodation, it is still there. That's still a thing. Don't let that one just sort of slip into the dark mist that is COVID. And so I think that's one of the first challenges coming out of the pandemic to think about, to make sure that there really is still an underlying disability or an underlying sincerely held religious belief that we're accommodating, and go back to your basics. Remember that you're allowed to ask for medical documentation saying, what is the disability? What are the actual limitations? What is it about your particular disability or your particularly held religious belief that requires you to work from home, or where work from home would allow you to still perform the essential functions of your job? Don't skip that analysis. It's very easy to just sort of brush off as people say, I want to work from home. And remember that the pandemic hasn't changed the underlying requirement of a disability or sincerely held religious belief, even if it's changed how we think about what a reasonable accommodation is. And that's sort of the second step of the analysis. Don't forget that first part of the analysis.
Yeah, and by the way, just to add another 30 seconds on that topic, that isn't to say that you may not decide to allow employees to work from home whether or not there's an accommodation. It just likely is going to be a different decision-making process for each employer if the reason that the employee is asking to work from home is, I want to work from home, versus I have a qualified medical or religious reason to do so. And so you've just got to be really thoughtful about what is the reason here, because that probably changes what it's going to look like. So the only other thing that I wanted to add to this discussion is that courts are in real time hearing these issues, and as probably will surprise no one, they tend to be a bit in arrears. And so we're just now starting to get some decisions that relate to this, because it sometimes takes a couple of years for these facts to reach a procedural posture where courts are actually issuing rulings on it. And so this is a bit of a bonus to those of you who are actually paying attention right now, because it's not in the materials, but just recently, back in May of 2022, the federal court here in Minnesota issued a decision in a case called Kubal versus Power Systems AHS LLC. And for those that are good note takers, it's case 20-2296. But it's a case in a slightly different factual scenario than a request to work from home as a remote accommodation. It's an employee who brought a single claim, a retaliation lawsuit back in the days of executive orders. We all remember that. Claiming that they felt that they couldn't be forced to go back to work, that because of the executive orders, that meant they got to work from home indefinitely. And I'm not going to focus on the executive order portion of the decision, but the court made some interesting findings, and the court's approach was interesting with regard to this idea of the employee saying that they could work from home. This was a 19-year employee who worked in a customer service sales role at a company in Chanhassen, and the court said, you've worked there for 19 years. You know what the duties of this job are. And there really is no contest in this case that some of your duties need to be performed in person. You get walk-in customers. You can't deal with walk-in customers effectively remotely. You've got to perform physical checks of inventory. You've got to assist with assembly and shipment of products. And the plaintiff himself admitted that he couldn't do all of that remotely. And so again, the case isn't in the specific context of request for accommodation, but on the one hand, if you have an employee who was working from home during COVID, that may mean that the employee is more likely to be allowed to work from home after COVID. But at the same time, courts are certainly going to look to what are the specific duties of the job of the employee that we're talking about. And can they be effectively performed virtually? Because if they cannot be performed virtually, it's a very different conversation, even if you have an employee who is allowed to work from home during COVID. And I think the other piece of the equation is, how have your business needs changed? When you look at your business today versus what your business was in March of 2020, how have those needs changed? Is business faster now than it was then? Is business slower now than it was then? Are the orders that you're receiving more or less electronic now versus then? Because those are factors that are going to be considered in whether you're going to be able to effectively force an employee to work from home or from the office. I mean.
For the remainder of our time, we're going to kind of cover old issues in the new world. And so by that, I mean, we're going to talk about conducting investigations with a workforce that might be in person and might not be in person, talk more generally just about sort of general risks that that still exist, but how they might play out in the current reality of workforces that just work differently than they have in the past. And then finally spend some time looking specifically at trade secret and confidentiality issues. And so with that as sort of the framework of our remaining 20 minutes, I will turn it over to Anabel.
Thank you, Jack. So there are certainly some benefits to conducting a workplace investigation remotely, including reduced travel, cost savings. However, remote investigations can also have their own set of unique challenges that aren't necessarily present when investigations take place in person at the work site. So just to kind of run through some of these challenges. As a preliminary matter, employees who are working remotely may not know how or where to report a workplace issue, especially if they rarely or never come into a physical workplace. Where it might otherwise be easier to pop into their supervisor's office or visit with someone in HR. Additionally, when an interview is conducted outside an office setting, it's often more prone to being interrupted by various different distractions. When interviewing a witness remotely as opposed to in person, it can also be harder for the investigator to both build rapport with the witness as well as assess their credibility. Um, Various laws require employers to keep certain employee medical information private, and employers also have a legal duty to use reasonable care to protect against the unauthorized release of employees' personal identifiable information. So, when conducting a remote investigation, which might require sharing certain documents with witnesses, employers want to be careful not to violate any of these employee privacy laws. On a similar note, investigators must decide how best to maintain the confidentiality of certain business information, while also, if necessary, showing certain documents to the witness or witnesses. Investigators will also want to be mindful of the possibility that remote witnesses may be in the same room as another person who is not connected to the investigation and perhaps not even seen by the investigator who's interviewing the witness. This unconnected person may overhear the interview and perhaps see documents that are confidential and sensitive and that are shared with the witness during the interview. Additionally, remote witnesses may try to document or record the interview without the investigator's awareness or consent. So with these special challenges in mind, I want to touch on some best practices to implement when conducting a workplace investigation remotely. These best practices certainly do not cover the entire gamut of best practices and protocols to follow when conducting an investigation, remote or not. Rather, these are just recommendations that are specific to what to consider when you're conducting an investigation remotely. So for starters, employers should make sure that they offer a variety of reporting options. Can the complainant raise a complaint via phone, via text? Is there a website? Is there an email? And make sure that these different channels are widely known to the workforce. Relatedly, employers don't want to just rely on employees to educate themselves about company policy governing in workplace complaints, but employers really want to offer and make sure that all employees complete comprehensive interactive training. In an effort to eliminate interruptions and distractions, investigators want to make sure that they themselves establish a private closed space in their home or somewhere private to conduct witness interviews and where they won't be overheard or interrupted by others. And likewise, when scheduling the interview with your remote witness, you want to make sure that you ask the witness when would be a good time for you to talk confidentially and without distractions. So in these situations where a face-to-face interview is not feasible, we as investigators really want to aim to conduct interviews via video conference as opposed to teleconference. I think that there's real value in being able to read and respond to a witness's facial expressions and other body language to help build rapport with the witness and also assess their credibility. At the start of the interview, investigators want to confirm with the witness or ask the witness to confirm that the witness is in a private area with no one else present or able to overhear the interview. Additionally, at the start of the interview, investigators want to advise the witness that they do not consent to the witness recording the interview. And if there is a reason for you as the investigator to record the interview, you want to make sure that you check applicable law governing the recording of conversations. A number of states require that both or all parties to a conversation consent to recording it. So if you're in one of those states, you want to make sure that you obtain the witness's express consent before recording the interview. And additionally, you might want to also consult with legal counsel about whether to even record the interview, particularly if the matter is likely to wind up in litigation. And if the attorney-client privilege applies, you as the investigator want to advise the witness of the privilege, who it applies to, and make sure that the witness and any other participants in the interview understand that they are not to create separate electronic conversations, emails, texts, Jabber, Slack, etc., regarding the meeting. And importantly, investigators also want to be careful to protect private, confidential, and other sensitive information when sharing documents with the witness. So investigators want to be mindful not to use public Wi-Fi to conduct the interviews or send related emails, and to ensure that the interview is conducted using some sort of secure technology. Investigators will also want to consider how best to share documents in a way that preserves any necessary confidentiality. So perhaps it might be safer to screen share as opposed to emailing the witness documents. And relatedly, investigators may want to consider whether to ask the witness to sign a non-disclosure agreement prior to interviewing them. Again, depending on the nature of the investigation and the related documents, this may be a conversation that the investigator wants to have with legal counsel.
Let's talk litigation risks. This wouldn't be an official Minnesota CLE if there wasn't a hockey reference somewhere. And so the great Wayne Gretzky said, good hockey players play where the puck is, great hockey players play where the puck is going to be. And we want all of our clients and everyone watching to be great hockey players. So one thing we try to do every year is talk about the types of lawsuits that we're seeing be filed and what is the trend going forward that we expect in terms of litigation risk. One of the most visible types of lawsuits that are getting filed all the time are disability discrimination and failure to accommodate claims, which we've already spent a bit of time talking about today. Certainly work from home is a reasonable accommodation is one subcategory of that, but it also includes things like employees who have COVID and are terminated while they have COVID. Long COVID is going to be a really significant conversation, I think, going forward. And what is long COVID and how does it impact employees? And does it qualify as a disability for which a reasonable accommodation is necessary? And what would that accommodation even look like? Also, be a little bit careful about terminating employees in states where there are still mandatory paid sick and family leave obligations, in particular, if they still have paid leave remaining. You may want to give them an opportunity to use that leave, and so it's a tricky situation. If you need someone on that job today and they're not able to perform the job because they're sick with COVID, you may want to consult with counsel before making a termination decision. And also be careful about retaliation, certainly in those states, but also in others. You don't want to be retaliating against people that are simply requesting to use a benefit that they're entitled to use by under state law. And then we continue to see lawsuits. I monitor lawsuits almost every day, if not every day, just about every other day, that get filed throughout Minnesota. And I still see almost every day lawsuits being filed related to discrimination on religious grounds. And so just keep in mind that isn't just a small subsection of the legal community that almost no one has to deal with. It's a shockingly large piece of the pie. And so make sure that you're paying attention when you get a request that may have a religious component to it. Disparate impact claims, that's really just a subset of discrimination, but it's worth calling out separately just because I think it's a good idea for employers to think globally about their hybrid work policies and how it impacts employees, including those that may be in protected classes. What is the makeup of your remote workforce? Who's being allowed to work from home and who's being required to work in the office? Is there a gendered component to that? Is there a racial component to that? How are you enforcing your remote work policy? Are there your performance standards objective? These are all really important questions in terms of disparate impact, because even if your policy may be facially neutral, the question of how you're enforcing it makes a difference with the courts. Wage and hour, I think the employee independent contractor issues were complex enough before COVID, and now we've got to deal with hourly workers being asked to work from home where they really have a bit more control over their time. And so employers are going to have to be a little careful about ceding too much discretion to employees to do work from an environment in which they're not being monitored as strictly as if they were sitting in a physical office. Those designations, it's probably a good time to revisit either now or in the very near future, whether your employee and independent contractor designations remain accurate. And this all has added importance because of overtime. If you really don't have good, effective oversight over your employees, in particular your hourly workers, there could be a pretty sizable overtime bill. And so now is the time to get ahead of that, not wait until there's a claim on the back end that could result in some pretty substantial damages. And then clocking out and off the clock work is also really important, and I'll discuss that in a minute. There are still workers' compensation claims from home offices. I'm sure some of you have dealt with that already. It's not necessarily a brand new risk here as we sit today, but I just wanted to remind people that employees who are working from home are generally included under workers' compensation rules, and a hybrid workforce just adds to the complexity there. Failure to reimburse business-related expenses. There are still states that require reimbursement of work-related expenses. If you don't know if you're operating in one of those states, give me a call, because it is a very important requirement that's very easy for employees to decide to bring a lawsuit over. And then confidentiality and information security practices. Trevor is going to get to that in just a moment in terms of practical guidance, but anytime you've got hybrid workers or full-time work from home employees that are looking at sensitive information from the privacy of their own homes, it's going to increase the volume and the magnitude of privacy-related lawsuits. And then a couple of additional risks here are denial and miscalculation of sick and family leave. As I mentioned, there are still states that have mandatory COVID-related and non-COVID-related sick and safe leave and paid leave obligations. For example, the Washington Paid Family and Medical Leave Act and the Colorado Healthy Families and Workplaces Act. That's not an exhaustive list, but certainly if you have operations in Washington, Colorado, and haven't carefully thought through how you're going to deal with those employees, now is the time to do that. Whistleblower claims arising from an understanding of state and local COVID-19 related laws, and frankly, that can exist sort of on both sides of the proverbial political aisle. You've got employees who may believe that vaccine mandates are illegal or contrary to public policy and be mistaken, but there are also states in which masking and vaccination policies may be prohibited depending on the type of employer that you are, and especially as we go down south, we see a couple of those states with restrictions in place. And so you could be subject to whistleblower liability in those states as well, where the employee raises a legitimate concern about state law, and the employer ultimately retaliates against them. That's just not a risk that you want to take. And then wrongful death and workers' compensation risks remain an ongoing risk, especially with the remote and hybrid workforce. The previous panel talked quite a bit about a hybrid, about the taxation risks in terms of employees working in other states. Just remember that there are also litigation risks. Just anecdotally, I had a friend who was laid off while he was in Oregon. Thank God he was in Oregon. Employer didn't know he was there. If he was sitting in California and if they wanted to enforce a non-compete, they may have had a big fight on their hands. And so anytime you've got employees who aren't working in the state in which you have assigned them to work, it would behoove you to pay attention to where they may be located, because that can have a really significant difference in terms of where you get sued and under what body of law you might get sued. So what I don't want to do is just fly through the next couple of slides quickly. You can have them for your materials, but really it just expounds on some of the litigation risks that we've talked about in terms of hourly workers and remote and hybrid policies. But I think it's important that we get to confidentiality and privacy concerns.
All right, so in the time that we have, I'll do a run through kind of some considerations for protecting confidential information. And anytime I work with clients, usually on advising clients, okay, what's our strategy going to be for protecting confidential information, or in the throes of litigation, what do we need to do now that either we're having a fight about getting our confidential information back or protecting it? I always tend to gravitate towards three questions. What is it you need to protect? Why do you need to protect it? And then how are we going to protect it? And so I have some thoughts up here on what you need to protect, loosely categorized into the usual suspects and the new kids on the block. Pay attention though to the new kids on the block, given remote hybrid work environment. There are going to be new systems, new databases, new ways of transferring information or old ways of transferring information like flash drives that maybe are going to make a resurgence now with employees being in multiple places. I say flash drives, I could say like floppy disks if anybody still has those. Although floppy disks are safe because nobody has a 3.5-inch drive anymore. So store all your stuff there. But it is worth not just the lawyers, not just the HR personnel, but it is worth having business personnel involved in conversations about what do we need to protect? What is sensitive to our company? That should be a conversation that may begin at the top of the house, but frankly should be going all the way down to the bottom of the house as well, because the C-suite may have different ideas about what is confidential, what's important to protect than the line employees. So this is a good time. Return to work, hybrid work environment, our company policy on all that. This is a good time to have new, refreshed conversations about what is our confidential information? What do we need to protect? It's also a good time to have conversations about why do you need to protect it? And yes, I quoted a statute up here, and everybody's eyes are going to glaze over, but I will point you to the red text. This is from the Federal Defend Trade Secrets Act. Most states that have trade secret laws just copy and paste from this, copy and paste from the Uniform Trade Secret Act with some variations. And even states that don't have written trade secret laws that rely on judges to make up trade secret law or enforce trade secret law. It's going to come down to the same questions in terms of why do you need to protect it? And it's because to get trade secret protection, you need to show that you took reasonable measures to keep that information secret. Coca-Cola does not post on its Facebook page the secret formula to make Coca-Cola. If they did that, the secret formula would no longer be like the best trade secret in the entire world, unless you're a Pepsi fan. So have these conversations, have the lawyers, the HR personnel, have these conversations with the business to say, this is why it's so important, because you get special protection if you have a trade secret. There are also other considerations. I've listed some of them here. HIPAA, FINRA, and the SEC, other federal agencies, other state agencies will go even beyond trade secrets. They'll say, customer information in certain contexts needs to be really closely protected. Anyone who works in the financial services industry knows that the SEC kind of cares about that a lot. So that's why it's important to protect it. And again, that can be consistent messaging from the top of the house to the bottom of the house. We as a company take this seriously. We need to protect confidential information. Okay, the part that we really care about, particularly now that Ryan is walking to the front of the room, is how do we protect our confidential information? There are some things that probably everybody in this room already knows: non-disclosure agreements, confidentiality policies, training, best practices. But think about how the how is going to change in remote work environments. And frankly, this is not a question that I can answer for you. This is a question that is going to require a lot of conversations with IT personnel. What systems, what technology are you using? Are you using VPN? Are you using some sort of remote box or Dropbox or online cloud storage system? So have conversations with the business, have conversations with the IT personnel. Maybe it's different department to department, and that's fine. That's going to work for your business. But start having conversations about what information security measures, what electronic measures we can take. Don't forget physical measures. I think everybody who walked in today, you got one of the little scanny codes either on your phone or one of the lovely little stickers, and I still have my key card. those are not going the way of the dinosaur. You need physical security measures. That's just an easy, low-hanging fruit to make sure that you're protecting confidential information. And this is a good time to have conversations about what to protect. It's also a good time to have conversations about how to protect it, updating policies, rolling out handbooks, rolling out new confidentiality policies, along with or as part of a comprehensive remote work strategy. On the quick topic of non-disclosure agreements, it is very common and very safe to have a non-disclosure agreement that prevents employees from disclosing confidential information and trade secrets. You may all, this is beyond the scope of this particular presentation, but you may all be aware that states and the federal government even are starting to kind of crack down on non-competes and customer non-solicits. That is coming. Non-disclosure agreements right now, protecting confidential information, are currently safe and frankly are probably going to continue to be safe. Everybody recognizes that that's important, but be careful because there are some states out there, and we've listed some states up here, or the states up here, that are starting to crack down on non-disclosure agreements. And they're doing it in the context of you can't prevent employees from talking about allegations of sexual harassment or allegations of discrimination. So the laws start from, I think we can all agree, a good place, that we're not trying to we're trying to curtail employers just sweeping that all under the rug. Problem is, a lot of those statutes are written very broadly to the point that they could touch on non-disclosure agreements that have to deal with confidential information. They're easy to word your agreements so that you comply with those statutes. It is not a difficult task to do, but it is a task that you want to pay attention to because if you get it wrong, then your whole non-disclosure agreement in some states can be out the window. And then you're left out there with no contractual protection of your company's confidential information, which is a bad thing. The last thing that I'll say is don't let common sense escape you. Remember the basics. Have exit procedures. Have HR involved in those exit procedures. Have managers who are actually performing exit interviews or who may be performing exit interviews. Have them involved in the exit procedures. Ask for your confidential information back. You have to take the basic steps because if you ever try and recover it in litigation, you want to be able to say, yes, we asked for it back. Some of the most fun cases I've ever had are when I'm defending against allegations that my client has misappropriated confidential information. And you just say, did you ever ask for it back? And then another kind of awkward silence as they realize they never did. And don't give up. Asking for stuff back one time during an exit interview and not getting it, that's not enough. Don't give up. You need to take repeated measures to show everybody that you take this seriously, that you want your confidential information back. And so one time is not good enough.
All right. Jack and Anabel, Trevor and Drew, thank you very much. I've got to say that applause, we just don't get that when we're doing this all online. So thank you out there. We're going to take a 10-minute break now. Before you go, however, whether you are going to your kitchen or just around the Dorsey offices here, please do remember to sign up for CLE credit for each of these sessions and get them submitted through email, just to make sure that you are getting the credit you are due. So with that, we are going to take a 7-minute break because the boss told me so. We will be back at 10:40. Thank you.